Good afternoon, ladies and gentlemen. Welcome to this meeting of the Randwick Local Planning Panel. I'd like to acknowledge that we're meeting on the land on which the Bidjigal and Gadigal people occupied on the Sydney coast, being the traditional owners and custodians of the land on which we meet today. On behalf of the panel, I'd like to acknowledge and pay my respects to elders past and present and the Aboriginal people who may be here today. Due to unforeseen circumstances, the panel chair, Annalise Tu, is unable to attend this meeting. The alternate chairs are also unavailable at short notice. Therefore, in accordance with the EPN Act Clause 23, I've been elected as the chair of today's panel meeting. My name is Jason Perica, hello, and we're also joined on the panel by Peter Romey, who's a council-appointed expert, and Peter Ryan, who's a community member and representative appointed by the council. Ordinarily there'd be 4 members, however in accordance with our operating procedures 3 is a quorum, so 3 is a valid number in which to proceed today. I'll ask if there's any conflicts of interest regarding any of the items from the panel.
No. No conflict.
No conflict from me. That's also been declared in writing prior to the meeting starting. I should note that while no declarations exist, that item 3 related to Marine Parade, Sandra Robinson, who is a member of this panel, owns the company that prepared that application, and I think Kerry Hammer's son is an owner of one of the units in that building. Kerry Hammer is also a community member of this panel. And that's more for noting because none of the members on this panel have a personal or financial or professional relationship with either of those individuals, so no conflict is foreseen for any of us. We have, in terms of panel speakers, firstly I should say the 3 items we're considering are 3A Stanley Street, Randwick, 263 to 69 Clare Valley Road, Clare Valley, and 122 Marine Parade, Maroubra. I've got one more, which is 84 Maroubra Road, Maroubra, which isn't on my list because we don't have any speakers. For those first 3 items, the registered speakers that I have in front of me are for 3A Stanley Street, no objectors, and for the applicant, Mr. Vaughan Milligan. Yep. And I'll just check. I'll run through the names first and I'll just double check no one else thinks they've registered to speak. For the second item, Clare Valley Road, we have an objector, Mr. Michael O'Connor. And for the applicant, Mr. Anthony Betros, just walked in. And for Marine Parade, no objectors, but for the applicant, Reese Hamer, Helen McFarlane and Michael Heenan. Michael won't be attending. Anyone else? No, just... Okay. Now, our practice is only to hear from registered speakers, but sometimes it doesn't always go 100% smoothly, so I'll ask if there is anyone who believes they did register to speak and address us who didn't hear their name in those items. No? Okay, good. So the usual order of speakers is to hear from councillors first and objectors and then applicants. I don't think we have any councillors registered to speak to us today. Each speaker has up to 3 minutes to address us. That will be timed. There'll be a bell. There is the option for the panel to agree to a 1-minute extension, but we will be quite rigid on that, just for equity reasons. I can advise you that we've been provided with copies of all submissions and relevant information lodged with the application from applicants. There's no need to speak to your submissions, but if it gives you more comfort and you want to use that as a framework, by all means do so. The applicants may wish to comment on issues raised in Council's report, provide a response to proposed or the recommendation and address any issues raised by previous speakers. After each speaker, if you come up and address us, the microphone's up there. If it's not red, press it so it does go red because that means it's being recorded. And just stay up there when you're finished because panel members may have questions of you, and when we've exhausted those questions, then we'll move to the next speaker. So I would ask that you refrain from any personal criticism directed at council staff, any other individuals, other speakers, the panel, people who aren't here. I won't be chairing a meeting where any slanderous comments are made from others, so I just ask you to respect that. I'll just make a few other points. It's not a debate. You know, we're not back in year 12 trying to hone up on our debating skills. So don't try and see that as what this is. We really want to hear what your issues are, how these applications affect you, and then come to a determination. So anything you can do to assist in that would be appreciated. And particularly not being a debate, don't also try and denigrate others in an attempt to win a perceived argument. It's also not Q&A, chaired by Tony Jones, so this isn't a forum for you to put questions to the panel and then pause and wait to hear our answers. It's not that. While it's open and a public meeting, we want to hear from you. It's not that style. You can ask questions, but we'll take them as in you raising an issue rather than waiting to be answered by us. We're an independent panel, so we're not the council. We haven't predetermined our mind on any of these matters, so there's a recommendation before us. We haven't made up our mind. We want to hear from you, and then we'll make up our mind. The last things to say are that this meeting is being voice recorded, not video recorded, as far as I'm aware. That's correct. So otherwise, there's to be no recording of this meeting. Any such recording would require our prior permission, which hasn't been sought nor given. What we'll do is fairly simple. As we've got 4 items, we'll hear from each speaker that's registered to address us. You have your 3 minutes with the possibility of a 1-minute extension. We'll exhaust the questions. We'll move on. At the end of hearing from all speakers for each items, we'll then move on to the other item rather than making a decision in front of you. Then as a group of items, we as a panel will deliberate in another room after the meeting concludes and all those 4 items are finished. And then by majority vote, the chair has a casting vote, but not today because there's only 3. By majority vote, a decision will be made in that forum when we adjourn by majority, and then that will be published aiming for tomorrow, and I don't think that's not been met in the past, so we'll be doing our best to publish those reasons tomorrow, along with the verbal recording of this meeting. I imagine that gets published as well tomorrow. So hopefully that all makes sense. If there's any questions on procedure, I'm happy to take them before we start. Is that clear? We listen, we hear, we ask questions, then we deliberate and publish the decisions tomorrow by majority. Great, that's good. Then the first item is 3A Stanley Street, and no objectors, and we've got Vaughan Milligan. If you could come up, please. Great, thank you.
Thank you, Mr. Chair and panel members. We're grateful for the opportunity to address you today. I'd like to speak to the report. Our application is recommended for approval by staff, and we're also very grateful to the staff's assistance throughout the process, that being the Design Excellence Panel and also the planning staff and the associated engineering and other departments. We've worked hard all the way through this process to come up with a design for the additions to our building, which we think achieve a good balance between what our client is seeking, some paring back of what they originally sought, but they're very happy with the design that the staff are now supporting. There are some conditions recommended in the report which I'd like to go to. There are a number of conditions in part 2 of the recommendation before you. About 5 conditions. We're happy with basically all of them. There is only one condition, which is 2C, and that's suggesting a slight increase in the side setbacks for the upper level we're seeking to this building. The 3 lower levels are all at a side setback of 2.35 metres. The staff have recommended in their report, and I'm assuming it's probably a typo in the actual recommended conditions.
Yeah,
in 2C,
3.5 should be 2.5.
2.5 rather than 3.5.
And
And
so
so
that's a typo, yeah.
Exactly, thank you. So we were wanting to bring that to your attention. If the committee were minded to go with a recommendation, we'd hope that would be 2.5.
Yep.
What is going to be the most efficient way of constructing this upper level is to build off the existing walls at 2.35.
Yeah, I understand.
The 150 mil increase is going to introduce, whilst not insurmountable, there's potential there for waterproofing issues, which we think we'd hope to try and avoid. Otherwise, the conditions are asking for changes to the building, which decreases impact. We're happy with the rest of those.
For 2C.
So,
Okay, questions from the panel? Sure.
Mr. Milligan, are you the architect or the...
our architect, Peter Princey, is here if you have any particular design questions.
Okay.
Yeah.
I did have one question. The elevations show that the original brick balustrades on the Stanley Street elevation are being removed and replaced with what looks like a balustrade of using
Palisade.
palisade or
Metals fences.
metal or timber or something like, it doesn't say. There's no notes to explain what's proposed there, so could you just
I'll
explain
clarify.
how that is meant to work?
And while you're doing that, can you also advise if any of the doors that are shown as being removed or replaced, whether any of those are original to those balconies?
I might defer to Peter just to make sure that's correct.
Thank you. Basically, the balustrading, we had wrought iron balustrading proposed for the upper level. However, now with the increased setback and the increased roof, that probably won't be visible. So we're more than happy to have the existing brick on the lower levels.
Yep.
That's not a problem. We're quite happy to have that as a condition.
And if there's existing extant doors to those balconies, you'd be happy to retain those?
Yes, we would be.
Right, okay.
Definitely.
Yes, because those doors are currently not visible because they're behind the infill
That's right.
in the balconies.
That's
But
right.
if you open up those balconies, those doors will be visible.
Yes.
And we don't know how many of those doors may be, original ones may be still extant, but if they are, we'd like them to be retained.
I think they are original and we're happy to retain them.
Okay, thanks.
Can I ask
Thank
a
you.
question on that same issue? If we were minded to agree with you to delete condition 2C on the basis only 150 mils, being a little benefit, there's a condition that does require the external walls to be either face brickwork or rendered and painted in a dark finish. Which of those are you likely to go for?
We're mindful of the stability of the site.
So rendered and painted.
So it would probably be rendered and painted.
Okay. Any other questions? No. Okay, look, we'll make a decision. Look, I can say I'll be tossing up the benefit of that 150 mils versus I can understand there's an issue there. The other things I'd be looking to talk with the panel about is the necessity of reducing the ceiling height over that stair to 2 metres, particularly given the setbacks 1.5 metres. But we'll talk about those things and make a decision that'll be published tomorrow. Okay, thank you.
Thank you, Mr.
Thank
Chairman.
you.
Thank you.
The next item is 263 to 269 Clovelly Road, Clovelly, the childcare centre, and the speakers. The registered speakers, and we'll deal, as mentioned previously, we'll deal with any objectors first. We've got Mr. Michael O'Connor.
Good afternoon, panel. I represent the local community, Clovelly community, who object to the proposed increased numbers at the childcare centre, 263 to 269 Clovelly Road. There are two major reasons for this, being noise and parking. When the original development application was passed, there were a number of conditions that were to be monitored by the applicant, and there was an understanding that would be consultation with neighbours and a genuine listening to issues. This has not happened. Conditions 68 and 69 relate to noise levels, should comply with the acoustic report, and they would be monitored by the developer. This did not happen. I commissioned my own sound engineers to look at the new DA, and test the current noise levels. The result and the report were sent to council. In short, the acoustic report submitted with the DA only talked about the levels of noise created by the additional children and not all the other 90 children that were already in the centre. And the noise levels on the day exceeded the levels detailed in the initial DA. The consultant that I engaged advised that without sound baffles, it would be very difficult to achieve the noise levels that were approved. My wife and I suggested acoustic treatment with the property owner and the director of the childcare centre, which was flatly refused. Our neighbour Lynn Gailey, who is retired and is at home while the centre is open, was concerned about the screaming and crying coming from the centre. When she asked about the children, she was fobbed off. The other issue is parking. In the original approval, staff were going to park in the car park located in Susan Lane and then fill up the surrounding streets. This does not happen, with staff filling Clovelly Road, Knox Street first, and then filling it's very rarely filled the car park. Subsequent to the original approval, the childcare centre leased part of the centre to iMove Physiotherapy, which is added to the parking issues and was never addressed when the change in change in use application was approved. With increased numbers in the childcare centre, there will be further issues with parking and drop-offs. This is not adequately addressed in the proposal. The childcare is already deficient from the original DA due to the physio and the caretaker parking. There are a number of us who've given up our time today to show our concern we have for our social environment in Clovelly, where we are a community where we respect our neighbours as we are aware of the small blocks and close connection. The Roly-Poly Childcare Centre does not have the same respect for the community, and if the proposal is approved, the conditions need to be enforceable to ensure the community is protected. It is a shame they are not prepared to work with the local community to ensure the childcare centre does not affect the local amenity. In summary, the residents submit that given the noise levels for the current number of children, 90, are not compliant with the original DA, the panel should not approve the increased number of children at the childcare centre until the current non-compliance is addressed. Any trial period is not supported by the residents.
Thanks, Mr O'Connor. Stay there for any questions.
Mr O'Connor, is it? Sorry.
Yes.
Yeah. You said you commissioned your own noise
Yes.
recording or assessment. Did we?
It was
have you
submitted
made
to
that
council.
available to the council?
Yes, it was
Yeah,
with
okay.
my objection, 271 Clovelly Road.
Okay. Thank you.
Other questions? I've got a couple of questions. So the basis of your concerns, I'm not trying to summarise, just in the noise
Yeah,
issue.
sure.
So they were given an original approval for 90. That was reduced, I think, when they applied for 150. There was conditions on that consent. I can't 68, 69. You mentioned that would have required certain
That's
noise
right.
levels to.
That's it.
And then after they started that, you commissioned a noise report, or as part of this, the objection to this.
So the original DA required the childcare centre to monitor. It was a self-regulating
Yep.
noise, which has never happened. And when with this DA application, there was a acoustic report submitted, but it only was only relevant to the 45 extra people, not the 90 plus the 45, which is obviously going to affect the noise.
Related to this you're talking about.
That's right.
Right.
But the original DA has never complied.
How do you know that if you haven't commissioned? So have you
Well, that's
commissioned?
why I spent $900 of my own money to do something.
And
that,
their
that
advice
shouldn't have
was
to
the
be.
existing 90 doesn't comply with the existing consent. Is that
Yes,
what you're saying?
that's in the report that I
Right.
submitted
Okay.
to council.
Right. Okay. And they've verified the times that didn't comply with.
Well,
And
it
you've noticed, your reason you commissioned that is you're concerned yourself from the
Yes.
noise. And so what's been your observations of the noise impact to you, when and what's in the nature of that noise concern? Where do you live?
I live at 271,
Right.
so I'm right next to it.
Yeah.
I'm lucky enough that I work during the day, so it doesn't
Yep.
affect me greatly. My wife works during the day, but my daughter works from home, and it affects her. And I know it affects Lynn, my next door neighbour, who is retired and at home, and well, I know the other people in Clovelly Road, and also some of the people in Knox Street. And
And you've been there a while, I imagine neighbours have
I've been there for 10 years.
While the RSL was there?
Yes.
Was it worse or better then? In terms of noise and
There's
parking,
much
just
more
out of
noise
interest.
now.
Much worse now?
Yes.
Why is that?
Well,
Just the noise.
my ears are still working the same as they were, and if anything, they've got worse. So
Right.
it's probably better. Look, the other thing was that there was a 9-inch or 9-inch in the old terms. What's 230? 350 millimetre wide full brick wall on the outside of that picture theatre, which was an original picture theatre, so that no noise came out of there. Only when they opened the door was the only time any noise came out. Now it's completely open, and the childcare centre seems to put the crying children at the back near the rock wall, away from the rest of their children, so that they don't have the inconvenience that we receive. And again, we've asked in the past that there's acoustic baffles, all sorts of things, curtains, again,
No, it's all right. I was just asking if it was worse or better than ours. And you mentioned about the noise that your consultants said it'd be hard to meet them without additional noise baffling. Was that
Yes,
what you said?
that's
so,
right, yes.
So is their conclusion that with that additional noise baffling, they would be able to meet their?
they didn't think, thought that they'd have to, well, at first, they'd have to move the crying children away somewhere else. They said that shouldn't be the case. They said we shouldn't be able to hear the teachers speaking to the children, which anyone can. And I mean, anyone could come to my house and.
There's not a requirement that everything's inaudible. That's not the basis.
Not inaudible, but
No.
I think it's
there's
4 or 5
right.
dBA above the ambient noise.
Is there an expectation that you shouldn't be able to hear anything in it at any time? Is that an expectation that you have?
No.
Right.
Well, again, we've got our blocks are 6 metres wide, so
Right.
if someone two doors down has a party, we hear that. But that, I mean, we're in our community, we find that
And you mentioned that there's staff parking on Clovelly Road. How do you know that?
I can see them get out of the car. They've got a green dresses and whatever else.
And that's a regular occurrence?
Regular occurrence. And look, it wouldn't be so bad if they filled up the car park first, because the car park's at the back of in Susan Lane, and it's a bit of a steep hill, so it's much more convenient to park outside 271 Clovelly Road and walk to 269 than.
And do you have parking available for your own property, on your own property?
Look,
or you rely on street parking?
there's a rear lane right of way which we could use, but it's very difficult, so we park on Clovelly Road.
Oh, okay. Any other questions? No, I don't either. Thank you. Next, we have the applicant, Mr. Anthony Petros.
Thank you, panel, for the opportunity to speak before you. I can advise that the applicant accepts the recommendation for approval with the conditions for only an additional 12 rather than the 32 which were originally sought. Obviously, we would have preferred the 32, but they would take the 12. The main reason for that addition is that the existing children who are in the centre at the moment now have siblings, and those families are trying to get their children enrolled. So we lodged the application last December, a year ago, so that for this coming year, they would then have the benefit to be able to provide for those children to come to the centre. Those 12 will assist somewhat, but won't fully fulfil the demand that is generated by the additional siblings. In that regard, given that it's predominantly sibling demand, there won't be a significant amount of on-street parking generation. You'll note in the executive summary of the report that just in terms of then addressing the concerns raised by the objectors, the second sentence says the existing childcare centre is operating in accordance with the development consent granted under the DA approved 14th of April 2015. So to me that then would suggest that condition 68 has been assessed. Now, in relation to the noise monitoring, there was a report done by RSA Acoustics in March, and then there was a further one done in August. So what the benefit of the, so we then reviewed the Marshall Day acoustic report, which identified 30th of January 2019 was the only period when they did their acoustic testing.
Consequence of that report?
Sorry, yes, that's the one, sorry. After that, the applicant then provided noise amelioration measures to the levels that actually don't relate to this application. So that was in direct response to concerns raised by the neighbour. So I think that contradicts the lack of response that was stated by the objector. Those measures are in place and they've been inspected by the acoustic consultant in the September report. You'll note from the report that there is abundant outdoor and indoor area to cater for the additional children, and we're still well below the potential numbers allowed. So really it does come down to, they are right, it does come down to acoustic and parking considerations. I'm not sure if you're familiar with the original approval in 2015, but what the report did identify is that there would be 5 places on the eastern side of Knox Street, and they're in place. You would have seen that road widening with the time spaces. That report also included 4 spaces on the western side of Knox Street. Now those spaces have never been implemented, so the 90 children operating are actually operating with a parking well below that envisaged by the approval. So there is also scope to provide those extra 4 spaces in accordance with the approval in April 2015. We've done numerous Sorry,
Extra
just
minute,
take a
yep.
30 second. Inspections of the staff parking, we've generally seen 4 of the 7 spaces occupied, and that's consistent with the photographs within the report. We've also done near map observations over the last year or so, and that is also consistent when you're looking at the aerial photographs, noting that the staff parking is all day, so it doesn't really matter what time the satellite went over. So in our opinion, the client has been responsive to concerns raised, and we've had a to and fro with council both in relation to parking and acoustics, and have been quite responsive in relation to both those aspects. Happy to answer any questions.
Questions? No questions, Peter? Okay, I've got a couple of questions. No particular order. I'm just trying to work out this argument about the parking availability of 4 on the other side of the street, whether that actually helps or doesn't help your case. So the argument could be that by not providing those, it's worse, and so you've got an insufficient amount of parking and you're increasing the demand, so that'll make an existing situation worse, and that's reflected by not having those additional 4, versus, I guess, the other argument side of the coin, which is, well, no, if there is an issue, we've got the flexibility to go for the other 4. So I'm just trying to grapple in my head the argument
sure.
there with that.
So in the morning and afternoon peaks, the 5 spaces on Knox Street and the spaces on Clavelli Road have been able to cater for the 90 children,
Right.
which is less than the parking that was actually anticipated by the approval.
Right.
So
it wouldn't be ideal to have the parking on the other side of Knox Street because children and parents would be crossing the road, I guess, which wouldn't be an ideal scenario for safety. It's better on where it is from a safety perspective.
So when they did the eastern side, they actually shifted the centre line of the road so that you could actually provide that width of movement of,
And
in
those
terms
works
of
were
door
paid
opening,
for
those
by
sorts
the
of things.
proponent, were they?
Sorry?
So those road works were paid for by the proponent
Correct.
to be right, and
Yes.
relocation. Right, okay.
Yeah, I mean,
But was it the local traffic committee didn't approve it on the other side, or what? How did it come about that the other side?
We've been trying to work that out, and there's been no response
Right,
forthcoming.
can't quite get to the bottom of it.
Yeah. But just from my experience with childcare centres, so over 10 years, you just get the child out on the curbside. You know ahead of what you're going to do. And then just crossing Knox Street, there's good sight distance up and down that street.
Right, but it'd still be subject to the local traffic committee
Correct,
approval if
yeah.
that was the way.
But I think, just given with only 12 children, with a significant component of that being siblings, I don't think there would be any discernible impact on the street network anyway.
Now, everyone's been well behaved tonight. One of the other things I've got to mention up front is not to talk while other people are talking, be respectful. Everyone has been, so I know it's difficult sometimes when you might disagree with what's being said, but I appreciate everyone respecting, showing some courtesy and respect. Thank you. The noise amelioration you said was done. What was that after so was I right in hearing your own report was done? There was a neighbour's report done. Your consultant looked at that neighbour's report, identified a non-compliance, and then subsequently introduced some noise amelioration measures on the site, including where there's no work proposed. What is that right? That's what you said.
Correct.
And if that's the case, what were those works that were done?
So it's in the applicant's acoustic report dated 11th of September. There's an area where there's some glass panelling, and then there was like a mesh screen above, which wouldn't have had any noise impact. That has been the glass has been raised.
Right.
And also, and that's at the lower levels where there wasn't any, where this is not actually the subject
And
of
what was
application.
raised? The glass. So the mesh
Correct.
was replaced by glass, which
That's
is more
right.
solid than mesh. Okay. Okay.
And then there were some concrete areas or masonry elements on the lower levels as well.
Yep.
And they've been changed to a soft finish to avoid any bouncing of acoustic impacts.
And did the noise consultant subsequently measure noise
Yes.
emissions to confirm they complied with?
Yes. And that's in the that 11th of September report.
Right.
And he said, I've inspected the acoustic recommendations. It was noted that all recommendations have been incorporated successfully. And then they did a remeasurement of the 3 properties, being 53 Knox, 271 Clavelli Road, and another one that was the back of front of 271.
Right. Can you say anything about the staff not using, the reason there's space in the staff parking at the back is because people it's too far to walk the front door, so they park on Clovelly Road? Have you got anything to say about
No,
that?
you know the parking's there. If they are doing, I'm not contradicting what's been said,
Yep.
but I can't see any reason why one wouldn't park there given it's a dedicated space.
Right. And in terms, and you also mentioned, just expand this whole issue about 12 spaces and siblings, and what was the argument there? So the priority being given what I'm understanding you said was that you've got kids there, there might be a brother or sister, and the priority would be to fill up those extra spaces with brothers or sisters, which means they'd probably be in the same car, which wouldn't be extra movements. Is that what you're saying?
Exactly right. And this DA has been an exact response to that demand.
Right. And to meet the extra, whatever it is, 32, let alone the extra 12 that you're willing to accept.
Yeah.
And so if that was the case, and if the panel was minded to support the application, would there be any concern with the plan and management addressing two further issues, which is that allocation of additional spaces to siblings as a priority?
Definitely.
Not a problem.
Yep.
And measures to look at the management of staff parking to ensure they're using available staff parking before any public parking?
Of course, and that has in fact been directed since receiving objections. So that makes perfect sense. And just reiterating that this is also a trial. So no doubt there'll be further monitoring of both aspects of the proposal.
Okay, thanks. I've got a question to council staff, and that's about recommended condition 1 to do with the trial period. Because ordinarily, if there's a recommendation for a trial period for an additional number of children, additional number of hours as a pub, then at the end of the trial, there'd usually be a base that it'd pull back to, so the approval in the trial's only for the additional being sought. In other words, there's 90 at the moment. The recommendation is that be allowed to 102, so the trial for an hour would be for the extra 12 to see the impacts, and then at the end of the year's trial, a verification of acoustic and parking impacts, and then an assessment when a new application is made of whether they can continue with 102 or go back to 90. But I couldn't see anywhere in the condition that says at the end of the trial, if it's not successful, they go back to 90. It just, so should it?
Yes, it
Right.
will be. We could, amended the
That would be
conditions.
intended. That's why I assumed it'd be the intent. I just couldn't see the words to say that.
Yep.
So it's not intended that at the end of the trial, if they have adverse impacts and were found not to be acceptable on a new DA, they just go back to 0. The intent of it would be that they would then not get the extra 12 anymore after the trial. Is that right?
That's correct.
Right. Okay. Any other questions?
So with the September report by the applicant, how many children playing outside was that based on?
They actually did something that is not typical. They got all the children to go outside at once, and I think there was 75 children at that point in time. It says, no, the noise measurements from the outside play areas was the worst case scenario, having the maximum number of children in all outdoor players simultaneously. And it says it would be below current background levels.
But not holding signs up saying shush.
Correct.
Right.
Thank you.
And I also read somewhere about the assumptions on the acoustic report were that there'd be, I think it was 45, there was a number stated about the assumption of the outdoor use of play space by a certain number of children to meet those compliance levels in the noise report. Otherwise, is that?
Correct. I think they said there was
and is that
45.
Something I can, so again, there'd be no concern with ensuring that whatever recommendations to meet acoustic performance by a noise consultant, they should be reflected as conditions of consent.
Correct. And there's another 3-month requirement that they do a further retesting.
Okay. Other questions? No. Thank you.
Thank you.
As mentioned up front, we'll move on to the third item. There's no point hanging around because we won't make a decision and let you know what it is today. You'll have to read it on the web tomorrow. Thanks for attending. The next item is 122 to 124 Marine Parade Maroubra Residential Flat Building, recommended for refusal. We don't have any speakers for objectors. I'll just confirm no one registered to speak. I did confirm that up front. No one turned up later who thought they registered. So we have applicants' representatives. It'd be good if you all get close to the microphone. I'm not sure who the nominated speaker is, but it might be that if there's questions, they might go to, I'm not sure who, depending on what the question is. So who's coming up?
Reece Hamer, one of the owners.
Yep.
Helen McFarlane from Addison's Lawyers.
Can I just check with council staff, and excuse my ignorance as a part-time or a one-off chair, is there a limitation to the number of speakers from an applicant? How does that work?
The current procedure is 1 speaker
Right, okay.
per site.
Right, okay. And so you're aware of that, so you're the nominated speaker?
No, I wasn't aware. I thought we were being provided allocation for 3 speakers.
No, that's not the case.
Okay, I think potentially.
It's up to the panels. You know, you could decide to allow other
Can you limit yourself to two? I'm happy to hear.
others to answer questions if
Yeah.
you want. Yeah.
Yeah, I'm sure there'll be some questions, so I might be the third person who says questions. So have a think who your best two are to summarise your case. Not best two is not the right term, but and then. Sorry, I did word that correctly. Reese, is it?
Yes, that's right. Okay, you ready to start?
Yep.
Okay, so I'm one of the lot owners from 124 Marine Parade. I purchased the property in 2014, and I was understanding of the building structural issues, but I was given confidence that the current owners corp were looking at investigating rectifying the issues, and they actually had some consultation with council on a renovation repair method. But as a couple of strata meetings went in, it was clear there was a division in the strata community, and it was also advised and experience with rectification works that the costs would exceed anything that was economically feasible for repair. So we began a process in a meeting to investigate a different repair method, which would be complete demolition, and we've been guided by a strata lawyer who sat on the strata law form for the Strata Scheme Development Act. So we're in the process at the moment. We held a majority vote to form a strata renewal panel and committee, and essentially the panel has to put together a plan, and once that plan is resolved, that goes back to the owners. At that point in time, we need 75% lot owners' consent to proceed. So we're in this is an essential component of forming that plan. So I think I'll hand over to Helen to speak about the actual design, unless you'd like to do questions first.
Why don't we hear from everyone, and we might have questions that come back to you afterwards.
Okay. Thank you, Mr. Chair, panel members. I just want to elaborate further about this is a bit of a chicken and egg situation for this strata scheme. Basically, the strata scheme renewal process is really aimed at developers coming along to an owners corporation with a development proposal or a collective sale. In this case, the owners corporation are doing it themselves, and that's quite unusual. So therefore, we have this situation where they're funding it and they need to get finance, but getting that finance is dependent on some certainty about what the redevelopment proposal will be. So therefore, at this stage, we haven't been able to obtain owners' consent to the lodgement of the DA. So still proceeding with the DA, what it's hoped is that this panel will find that notwithstanding that they can't legally approve the DA because they don't have owners' consent to the making of it, there are no merits reasons why this development application should be refused, notwithstanding the recommendation for refusal. I'd like to actually make some comments on the recommended grounds of refusal. So, ground one, you can't approve it. We accept that. But we'd like to knock out the merits issues, that there's no merits issues as to why this development should be refused. So in terms of ground two, which is the clause 4.6 variation, I can't speak to supplement that. It's a written document. You need to satisfy yourself of that. We don't agree with the comments that have been made by the council in the report. As to the desired future character, I'd like to draw your attention to pages 11 and 12 of the clause 4.6 variation request.
Yep.
Visual bulk is addressed at page
We do
13.
have that. It concludes is we talking about the updated one dated 11
Yes,
December?
thank you.
Right.
We are talking about the updated one. And sorry,
Yep.
that's why I'm referring to the page numbers in that particular
Yep.
document rather than the council report.
Sure.
View loss is addressed at pages 14 and 15. There's also the Richard Lamb report.
Yep.
In terms of sufficient environmental planning grounds, this is one that the panel members will be quite aware that often is given very short shrift in clause 4.6 variation requests. This is a rather extensive one. And in particular, all of the grounds relate to the exceedance of the FSR control. And they're on page 17 to 19. Now, the council concedes that the new building will have higher levels of amenity than the building, but says there's not sufficient environmental planning grounds, but the report does not address all of those grounds. So we'd say that the panel could be satisfied having regard to those extensive grounds on pages 17 to 19. Consistency with the objectives of the FSR standard, they go back to the Webby considerations, and that's addressed on pages 11 to 14. Consistency with the R3 zone, that's also
Yep.
addressed.
We've read the submission.
Thank you. The other grounds I'd like to address, which I can talk about, a desired future character. Now, the council's report says, well, it doesn't comply with the desired future character because it doesn't comply with the FSR standard. Compatibility means in harmony with the desired future character. Doesn't mean it has to be the same. In particular, we'd like to draw to your attention the Design Excellence Panel comments at 124 and 126.
Look, you are over time a bit, so I would ask you to sort of try and truncate the rest of your speech. And even though you had three registered, one of those isn't here, which is Michael Landon, so we're only back to two anyway. Yeah, maybe just try and be quick on the rest.
I will. View loss, I'll draw your attention to the figures in the report, which indicate that there will not be substantial view loss to 120 Marine Parade or to Unit 9. I'd also like to hand up shortly a real estate ad for Unit 9, which sold on the weekend, and that has much better photos of what are amazing ocean and beach views compared to the figures that are in the council report. And you can see for yourself, panel members, that there will be no, not even a moderate impact on views when you undertake the tenacity. So we disagree with the council's conclusions on tenacity. Visual bulk.
Yeah, I'll just ask you to wrap up the remaining points.
In particular, I want to draw your attention to the ADG. It's a guide. There's also design guidance. We comply with those. In relation to parking, there's only one car parking space at the moment. We provide 16. We don't provide we don't comply with the DCP requirement. However, there's off-street parking, and all the residents currently in the building park on the street. The draft LSPS for the council states that they're one of the things the council intends to do.
Summarise. Yep.
Is to evaluate other space-efficient modes of parking. The external wall height has no impact in terms of the non-compliance. And that's just a very brief
So I'm not
response
trying
to...
but they do need to be equitable, otherwise...
No, I understand that, but if this is a circumstance where the council actually
has recommended refusal, that's why I've given you some latitude.
Has made some misleading comments and inaccuracies in the report. So, thank you.
Not sure about misleading, but we'll let that one slide for now. Okay, questions from the panel?
Yes, thank you for your presentation. You acknowledged at the beginning of your presentation that without owner's consent, the panel is not in a position to approve the application.
That's
Can
correct.
you just, I didn't catch what you would like the panel to do.
Well, we would like the panel to do one of two things: defer, so that we can get some certainty about, or get some feedback from the panel about whether they would approve the development, but for not having owner's consent. That's a legal impediment. We don't have it. We're not suggesting that you approve it. It would be unlawful for you to do it. So to defer it so that my client could go back to the other lot owners and say, well, look, we could get this redevelopment approved. It would be a feasible development. We can restart the strata renewal process. We suspect that there are some lot owners that are currently against the proposal who may change their mind if there's some certainty that this redevelopment could go ahead. If the panel is not minded to defer it, we would request that it refuse it, but only on the basis of the legal impediment.
Thank you.
Can I just speak on one of those points?
Only if it's directly answering the question.
Yeah.
Every question I've got to say isn't an invitation to make more points because you're
It is directly. So we've actually got a legal obligation under the Strata Scheme Development Act to formally follow a process, and that process is the Strata Renewal Plan. And to do that plan, it is essential to get feasibility of the plan. I can't legally go and present a plan to the owners which isn't a resolved plan. So I need basically a formal thing, a formal response to put that plan together.
But when you said before this is an owner-initiated proposal, which is unusual, if that's the case, why isn't there unanimous support or 75% support?
Sorry, I don't exactly understand the question.
I think you're differentiating this as being different to the usual taking over by a developer and as being initiated by the owners. But if that's the case, why isn't there either unanimous or majority support above 75%?
Any decision we make essentially at this stage is either a renovation with modification of common property, and that requires no more than 25% opposed. A collective sale or a redevelopment requires 75% in favour. a majority vote was held, and we're actually seeing around 75%, but a majority vote was held, which we won, in heavy favour to follow this proposal to rectify the buildings issue. So that's why right now it's not unanimous. There's 16 lot owners. There's a couple still that aren't in favour, and there's a couple that aren't confident without a thorough plan.
Could I just speak further, Mr. Chair, on that? With the DA, because it affects not only the common property of the current scheme, it also affects each lot.
Yes.
So to actually have a lawful giving of owner's consent to the making of this DA, we need not only a resolution of the owners corporation, every single lot owner, 12, has to give owner's consent to the making of this DA.
Yeah, but you haven't got that.
Pardon?
But you don't have that.
No, we don't have that. So we've got a situation here where what would normally occur is a developer would...
No, I get that. No,
Yep.
let's not go there. Okay, I get what you're saying. If you haven't got there, you're almost there. You might get there.
Yep.
If there's more certainty, it'll also help the banks. Don't need to repeat
Yep.
that. Okay, let's move on to other questions.
I'm interested also in to the extent to which the intensity of the proposed development, which is, I hear what you say that you don't agree with some of the contentions. To the extent to which the scale, the scope, the intensity of development is being driven by the financial formula, I suppose, as a owner-driven and funded project.
Well,
Can I speak to that?
Yep.
So my ambition at the beginning of this project was a feasibility of various options, and it quickly became evident that the ambition was to try and put a proposal that was at a lower cost than a renovation repair, and that is the desired outcome. So we'll still be running at a significant loss to the owners, many of which are here today. There's a certain threshold where I think we need to target to get to 75% support, and at the moment the projection is I guess between 200 to 300,000 in deficit for the lot owners, which is about equivalent to a major renovation repair that doesn't resolve any compliance issues, which there are a significant amount with the current building.
So the basic proposition for the owners would be you're better off spending that order of money and having a brand new building that'll last a long time. You'd say, as architects, and contributes much better to the surrounding area than spending an equivalent amount and doing up a building that's still going to have ongoing problems and it's not as good for the surrounding area. That's the essence of your...
And the costing of the renovation repair probably is a 10 to 20 year resolution
I understand
as well.
Okay, other questions? I've got a question on, now I've lost my list. The height, and maybe it's something you can answer with your planner, is it's a little bit complicated this side because there's changing levels. You've got the driveway, you've got some areas that are raised courtyards, and I was looking at the height non-compliance, and it's quite a convoluted existing ground level, which I took to be, well, that has to be existing man-made ground levels on the site, not the surrounding assumed street level that you'd use using the Batar court case methodology. You haven't used that. You've used the floor levels of man-made structures at ground level on the site. Generally, they're higher than the street. That means the apparent height is less because the ground level's higher.
Yep.
But looking on the site today in that area, particularly next to the driveway, there's the existing man-made levels well below street level, but that doesn't appear to be shown in any of your plans, which would be, I think, around where that curved element is at the end of the walkway on the sort of western end. So have you got anything to say about that? I'm just questioning whether all the existing ground levels have been used in your height plans.
Thank you, Mr. Chair. We understand you raised that this morning at the site inspection, so we're investigating that.
Yeah. Okay.
So that's a matter that if there's not a
totally
non-compliance,
clear
we need a
to me.
4.6.
You'd accept that it mightn't be totally clear.
Well, we're investigating that, and we'll let the council know. So that's probably another reason at this stage to defer.
And you'd understand from our point of, no doubt there's economics involved in this. There's a cost of demolition, there's a cost of rebuilding, there's got to be a return to make this stay as it is, otherwise you're left with a substandard building. I don't think many people would argue that the existing building's substandard. But you'd accept that we can't really. It's not our job to sort of try and add up the numbers to say, well, in order to make it feasible, you need 14 units or 16 or 17. And even if we did, the market changes over time. So that land feasibility and development feasibility changes, and it's not relevant to us. You accept that. Really, we've just got to accept assess the proposed building and the merits of it.
I guess the owners accept that, but I don't know if it's the owners as individual citizens' responsibility to understand planning instruments changing through times.
Yeah, look, it wasn't really a question. It's probably more a statement than a question. Look, it was one of the arguments in the clause 4.6 that I was it's probably related to that in terms of the number of units, which was, well, look, the building's substandard. In order to meet the ADG, the Apartment Design Guide, we need to make the units sort of bigger and the amenity improved, and it's that process of meeting minimum lot sizes and so on that leads to the FSR non-compliance. And the argument for that, which I'm questioning, is, well, that assumes that if you accept that there's got to be X number of units and then you multiply it. So it doesn't hold true if you don't accept that that's your starting point. And I guess I'm just trying to test the logic of that, because wouldn't it just be dependent on how many units you had?
I'd say it's an underdevelopment of the land if we were to comply with 0.9. The development that was done at 126 Marine Parade was by Smart Studio, so William Smart. We've got on the other corner the opportunity to have an Alan Jack and Cottier building. The 126 Marine Parade was approved in 2004, and that I think has an approved FSR of 1.49 to 1 at a time when the control...
You're elaborating on arguments again. So the question was, do you accept that the FSR is linked to the number of units, so it doesn't necessarily follow that by complying?
Well, even if we... No, not necessarily. I think that the additional units from recollection only accounts for about 7% of the exceedance.
Right.
Yeah.
So on some of the design brief that went to the architect, and this relates to height, aspect and lot size, we don't have the authority as an owners corp to take anything away or change people's aspect. So that was essential to the brief to the architect.
But it'd be a different argument in my mind if you had 12 units and you're saying they're substandard, we've got to meet ADG with 12 new units.
Yeah.
Then that's a different argument to say we've got to go from 12 to 17.
There's 12 residential, 3 commercial, 1 car space. So there's 15.
Yeah, but you're
units.
Replacing the commercial with bigger commercial, so that's out.
That was the other issue we had internally. So when the design was developed and we had to try and comply with the ADG, we didn't have enough parking to provide parking for 20 lots. So the shop owners got an increase of 10%, which was deduced to be an equivalent cost increase to the car space.
Right. Okay. Any other questions? No, I don't have any. Okay, thank you for your attendance. We'll move on, make a decision on that after the meeting. The next and final item we don't have any registered speakers for. I'll just confirm that's the case for Maroubra Road. That being the case, we won't, unless there's any questions from council staff, I might, from panel members, no questions from council staff on the last item, Maroubra Road? No? Okay, in that case, I'll declare the meeting closed at 7 minutes to 2. And as mentioned, we'll now deliberate as a panel for as long as it takes to make decisions on each of those 4 items. And you'll find that published on the web. Is there anything council staff need to add to clarify any procedural matters I've missed? Thank you. Good evening. Have a good Christmas.